Well, good afternoon, everyone. I'm Phil Christian, and welcome to our webinar this afternoon. For those of you who don't know, this is we're coming from Dream It Ventures. Dream It is a venture accelerator based in Philadelphia. I am the managing director of health for Dream It, and this is one in a series of webinars we're providing, specifically focused to help startups navigate the waters that confront them as they try to launch their businesses. At Dream It, we're focused on pretty much post-revenue healthcare startups. We've had a lot of success over the past 8 years or so, working with startups that are focused in digital health, and more recently, more and more companies are coming on in the medical device space. So this particular webinar, we're focusing on IP and regulatory challenges that healthcare startups face, and we are honored to have experts in that area. That we're going to have a lively discussion and some Q&A at the end of the discussion. I'll do some introductions. First, I'll say hello to all our panelists and introduce Ben Glenn. Ben is a part of Shay Glenn. Ben, you can wave so everybody knows who you are. Oh, well, maybe you can't wave. Okay.
There we go.
Okay.
Yeah, I'm suspended from the ceiling here. This is what I really look like.
Jim's having a little bit of technical difficulty there, but bear with us. We also have Jim Swick with Swick Consulting, Steve Brooks from Brooks MedTech. We have Kyle Bastraki from Coles & O'Connor. And we have Chrissy Campbell from Wayne Morris. So these are experts. We're going to have some lively discussion. As I said, at the end, we'll have some Q&A. I'm going to actually start off asking a couple of questions. I said a little bit earlier, of all the people on the webinar today, I am the least IP savvy. I'm a physician by training, so I'm the dumb one on the call today. So I'm going to just start with a question that I would have if I was a startup. The first thing I want to know is, of all the things I'm doing with my startup, how do I know what qualifies as IP? What should I pursue? Ben, why don't you launch the discussion?
Okay. Yeah, thanks very much for that. I'm really looking forward to our discussion, and apologies to everyone if I'm making anyone nauseous. Just, you can flip your screen over when you listen to me. And I promise you all, it worked yesterday in the technical test that we did before, so I don't know what happened. I apologize. But I think what I think about is, your IP can take, if we take intellectual property in just its broadest meaning, I think this panel really shows what that looks like. IP is not just, a patent application. IP actually is more about, what are all the ingenuity. I would think about it as ingenuity property. And that's why, we're going to see everything from trademark and copyright, or, patent applications, but even your regulatory strategy. I think when you listen, these are a pair of my favorite FDA bookends. When you hear about how you can literally strategize to get your way through a regulated scheme, I think that's really when you want to think about, that's what your intellectual property is, your ingenuity property. That's the way I like to think about it. I think if you have a lot of innovators come into their new enterprise with a very narrow focus, or they want to put things in separate buckets. And I like to think of it as a, if we were all down at the Philly waterfront there singing sea shanties, one of us would have one of those big, long, accordions. And I think if you think about it that way and you just smash that accordion down, from end to end, the beginning of your enterprise to the end, and think about everything along the way, that's the sort of holistic model that I hope that we can really enlighten and inform our discussion today.
Chrissy, you have anything to add to that?
Yeah, sure. I mean, as far as IP assets, almost every startup has the one that I specialize in, which is a brand. I'll go through in a little more detail some of the things that a startup should be thinking about. But when I hear startups talking to VCs or talking to potential acquirers, I hear the terms brand equity and monetizing the brand and brand building thrown around a lot. But one of the first things to think about is, do we have clearance, and is that brand available for use? Is it inherently protective, and how do we protect it? And it's necessarily a piece of IP that's applicable to every company, whether it's a Fortune 500 company or a startup. They all have a name, and they want to monetize it and build up equity in it.
And Kyle, I saw you nodding affirmatively.
Yeah,
You probably agree with that.
Yeah, Christy's absolutely right. You know, the brand itself and what we are, the trade name that we use and whatnot. Obviously, in certain industries, that has a greater value than in some of the other industries, in my opinion. But maybe that's even more applicable to the patent, because in certain areas, a patent does become an instrumental part of your IP asset. And in a medical device field, for example, that we've been talking about, certainly getting your regulatory clearances and your brand clearance so that you can go to market is important. But the opportunity to sell and prevent a competitor from taking some of your market share based upon your ingenuity is really based upon the patent and the patent applications and the patent portfolio that you put together. But really, as everybody has mentioned already, this is a spectrum of products that should be considered one encompassing of your entire, the strategy that you're going to implement. And that's why, often, and Christy and I know would agree, we work hand in hand with our trademark, our IP, and our FDA regulatory people in making sure that we have a strategy.
Yeah, I'd like to build on that. I think everybody's touched on some really interesting points. And you're talking about brand equity and thinking about your IP portfolio and how that interacts with your markets, your regulatory, your reimbursement. I have a slide that has a good speaking point here. I'm going to see if I can share my screen at home. Let me know if this is going to work. I will. Can you guys see the screen says, it should say addressable market?
Mm-hmm. It does.
Yeah. So, so this is a slide I like to use. So when you're planning your product and you're at an early stage, you need to think about what you can and can't do. What can you protect? What is the value proposition of your product that you're building? And in medicine, there are often multiple things that you can do with that product. And you have to think about what is each case use, and each one has a specific market size and a specific route to market. So if you think about each one of those in perspective to regulatory burden and reimbursement, let's see if this will work. Oh, yeah. So I put these two spheres on here, and the size of the sphere represents the size of the market. So if you look at the one on the left, this would be the smallest market size opportunity for the same widget. So small market size, high regulatory burden, difficult reimbursement. Going to the right, the larger ball would be lower regulatory burden, larger market, easiest reimbursement. Obviously, if you can find that sphere in the bottom right, that's the one you go to market with. Typically, what happens is your market size is mixed. Different opportunities may be bigger, smaller. The regulatory burden may be higher or lower. This is the kind of thinking you need to do up front. So what can you protect? What are you blocked from doing? How does that interact with your overall strategy? And then all of your product development, including your R&D, your evidence development, your clinical trial, bench testing, animals, all that will flow from this. So it's really, and it starts with IP, and so you really need to be thinking about these things really from square one and thinking about the entire process all the way through to save yourself some redundant studies, unnecessary studies, dead ends, high burdens. So.
Stephen, let me ask you a question on that, because some of the startups we have are really focused on mobile devices, wearables. We have companies that come in with hardcore medical devices, a lot of digital health. Does it really matter what the content is, or should everyone go through that same thought process you just outlined?
So, I think in mobile health, it's particularly important because some things are regulated and some are not, and that's a big barrier to entry, and it can affect your development process, but it can also be an asset if you're able to get through to the FDA. And I've spoken with some of the folks on this panel before about the same issue. you need to think about what are you trying to do, and also, if there's a regulatory threshold as to what is and isn't regulated, is that valued? So if you go through all the trouble to get through FDA and the market doesn't care, you've wasted a lot of time and effort. So this is also important, but really thinking about the value proposition of your product and who is your consumer, who is your customer. I don't know if you're familiar with the ICHOR process, where you go out and you speak to multiple customers. You're trying to interview 40 or 100 depending on the program. This is really critical, and really from an early stage, all of these thoughts, IP, branding, research and development, your programming, if it's computers, regulatory, reimbursement, all these things, you need to think about them early on.
Jim, I'm interested to get your input on that.
Actually, Steve said everything quite well, and kind of stole my thunder with the early stage stuff, because that's kind of what I focus on, and in the experience that I've had, and that includes the IT portion of it, or digital health. I'm working with 3 different companies right now doing just that, and working directly with FDA. Now, they've already done the ICHOR process, so they've already found that they have a valuable idea and that it's marketable. They've also already taken care of their IP and filed patents. But the thing that they also did early on was talk to FDA to determine whether or not they even had to go through a rigorous regulatory path. I encourage the folks that I work with to do that, and to do that as soon as possible. And the good thing is that FDA has made that process a lot less onerous than it has ever been before. So the ease with which they've made this process accessible to people early on without any fee, and yet they still provide good advice, I think is phenomenal. And that's what I would encourage most folks, especially in the early stage portion of their development, to start focusing on.
And Jim, it's great that the process is not as onerous as it probably once was. Does that include time? Is the time frame reasonable? Because a lot of the startups at least feel like we're under a time crunch. We've got milestones we've got to meet. We've got investors.
Oh God, yeah. I mean, you're preaching to the choir on that. And I think it's really critical that you get in and talk to them early. There's usually about a 30-day lag time. But I'm working with one group right now that in 2 weeks, we had a response and a panel set up. And that's the quickest I've ever seen. So it's a lot better. And they're actually focused on customer service. Wow. They're actually having people fill out surveys now, and they're concerned about their image in the domain, public domain.
Let me ask a real quick follow-up. When a startup approaches FDA, what information should they have prepared? What should they be ready to discuss?
Well, I mean, that's a different question, because there are documents that need some time to prepare, and you have to know which documents to fill in and provide to them so that the process goes smoothly. If you don't do that, and it can take 2 to 3 weeks to prepare the documents properly, and if you don't do that, you could be wasting a lot of time. And then you have a lot of back and forth and people sending things back and saying, well, you're not ready to do this yet. So that's where I come in. That's where I help with streamlining the process. I essentially provide templates so that, here, fill in this table to the best of your ability, and then I help edit it, and we move on from there.
Stephen, I know you want to make a
so these are, everything Jim said is perfect advice, and really terrific advice, and really, so I worked at FDA for 6 years in the Division of Cardiovascular Devices and Office of Device Evaluation. And when we were on panels, we would preach, it's just like this election, vote early and often. So it's never too early to come in and talk to FDA. There's a formal process called pre-submission, where you can come in at any time. It's not like the drug side where it's heavily regulated how many times you can talk to them. You can keep coming in. And I had seen everything from a patent application with a couple of questions in an email up to, 1,000-page clinical trial. or designed for a PMA. And you can come in at any point. It's never too early. And the review time, so if you submit it today and you put it into FDA, the official review time is 75 days. And at 75 days, you'll have a face-to-face meeting, which I would encourage you to drive down to Silver Spring because the back and forth can be better, or you can elect to just get a written response. And basically, you give them as much background information as you can or as you want, and then you ask specific questions. Often, if you get a good review team, they will comment on anything they see in your application, but they don't have to. So you should ask specific questions. We believe our regulatory pathway is a 510K. Do you agree? Question number 2, we believe this is our predicate device, product A, B, and C. Do you agree? Number 3, we think we have to do these 10 bench tests. Do you agree? And so on with animal, with clinical. Ask specific questions, you'll get written out specific advice. Now, the caveat is it's non-binding, so they reserve the right to change their mind in the future, but they do their best to keep their deal. So if in between when you first spoke to them and when you put your application in, a new landmark trial comes out or there's a safety recall and they've learned something, then they may have to change their opinion of what they've told you, but there may be other ways to gather the data. So really, it's a great idea. And the flip side of this argument, so I work with a group through the state of Maryland. I'm located in Baltimore. And there are 3 of us that help companies get from 0 to submit a 510K. And of the 3 of us, I am very conservative and like the FDA process, get it signed off. You can hire the best consultants of the world. But their opinion doesn't matter as much as FDA, might as well get it right from them. However, there's the time to put it together, and then there's this feedback, this time to get the pre-submission. One of my colleagues takes the exact opposite. If you can just write it up, if there are precedents out there that you can follow, if you have a similar product to another product, you're held to the same bar. So just put it in, start that clock rolling for a 510K. If you're confident, if you're novel, or if there are new nuances or questions, then it's always the right answer to talk to them. But in the pressure cooker where you've got milestones, you're burning cash, you've got to balance these time delays with with your strategy. And both are viable depending on your risk tolerance and what's come before you. Both are viable strategies.
And Ben, I know you want to jump in because you and I touched on that when we were in the Philly office.
Yeah, I was just going to say, I think that just to kind of get out, let's just crawl out to the tip of the spear here for DreamIt, and actually for a lot of the, there's a high preponderance of companies that are coming in that would really call themselves just digital health. And I found this myself just, going around the country and working with different accelerators. I think it was the Rock Health last year, they had their 5th anniversary, so congratulations to them. And there was a VC panel. It was very interesting. One of the investors, a question came in from the audience: how do I know that I have to talk to FDA? And these are all predominantly digital or IT plays. And I thought that one of the investors, one investor gave the exact answer that we just got from my favorite pair of FDA bookends about 510K, medical device, and all that. The other investor said, if you have to talk to FDA, you don't need to talk to me. And I think I would love to hear Steve and Jim, if they've, and I know Jim has done some of this specifically because we were up, talking about some of these things recently, but if there are any really crisp guidance about, I'm going to be making, I'm more of a, can we help these companies know, look, if you're like an app on the Apple Store, then, you probably are not going to be talking to the FDA. You're probably also not a real medical device. You're not really in the medical space. You're in sort of a fringe. You're off to the edge. You might still do some important work, but it's not going to be right in the heart of it, as opposed to, something that is a software or electronic component of a medical device. Say, for example, really enhancing the operable capabilities of any of the surgical instruments that are out there. Perhaps, I know Steve, he's MD, so he's throwing around all these things like widget. So, all those things that have to be improved as electronics get smaller and everything. So maybe Jim and Steve could, if they can maybe crisp up that edge for us, if you've got an app or you're pretty much doing something with a lot of software, is there a boundary condition where it's like, more, better than even chance, you better be thinking about an FDA strategy for your company.
Jim, do you want to start?
Sure, I'll start. Well, the one thing to think of, and it's pretty simple, is does your software or your application have anything to do with diagnosis, recommendations that could be considered for a clinical application, or will it interface with the data coming from a medical device in order to either compile it, analyze it, or move it from one place to another? I think that's a real simplistic way of looking at it. But as I said, I'm working with a couple digital companies right now. One of them has software, and it's just straight software. And all it does is it takes data from a machine, and it analyzes that data and comes up with recommendations. That's actually considered a Class 2 medical device, believe it or not. And we have to get the appropriate submission and approval from FDA showing validation that it actually works and is comparable to existing modes of analysis that already exist. So we have to compare the data stream and the analysis that we get for this new piece of software to existing modes of diagnostic capability. Steve, you want to go from there?
Yeah, so that's perfect advice. So there are two nice documents that are on FDA's website. You can actually Google them. FDA publishes these guidances. And February 9th, 2015, they published two of them. One is on mobile medical applications, and one's on medical device data systems,
right,
medical image storage devices. And this basically tries to lay out, there's definitely a gray area, but it tries to lay out what they regulate and what they don't, and it gives examples. And basically, if you are providing health and wellness advice, how do you improve your fitness, lose weight, nothing with medical risk, that's okay. If you are performing a paper function, you're automating something, so you're helping patients access their medical records, you're feeding your data from your glucometer, not automatically, but if you type it in, it'll suck it in, and your product sucks it into the medical record so your doc can review it. That's not regulated. If there's a published study and your product, you enter some data about yourself and it looks up an accepted standard. So an example in cardiology is the Framingham heart risk. So over 50 years of people in the Framingham area of Massachusetts having their heart risk and following them for outcomes based on a bunch of risk factors, it's pretty accepted, what your score is and what your 5-year, 10-year risk of cardiovascular device is. So if you take a patient's input, even if you're sucking it out of a PDF file and you're looking it up, but you're projecting this accepted medical fact or making medical calculations that are accepted, like calculating renal function, that's not a medical device. When you start doing a new analytic, or you start making recommendations and assisting a doctor, right, when that's where risk comes in. Maybe you're giving good advice, maybe you're giving bad advice, maybe it's cutting edge and it hasn't been reviewed and people don't know the implications. That's regulated. So that's kind of how you think about it, and obviously there can be a gray area. Maybe somebody published a paper on a new metric, but it's not validated, and you're going to plug in and project that metric. If you say, according to the DREAMIT score, you got a DREAMIT score of 5, that's okay. But if your app then says, based on that score of 5, you should, shave your head because you need to have brain surgery for your cancer, that's different. And that's going to be regulated.
Right.
So I would encourage you to look at the guidances.
Ben, when we last spoke, one of the questions that came up was, what are some of the most common mistakes that startups make as they approach this whole process, the IP process?
Yeah, I think that one of the things that we're seeing now, and I'm glad that Steve put up that one graphic that we had, and thinking about from beginning to end. I think that one of the common mistakes is that they don't think through, because what that graphic really showed is that you understood the market, you understood the regulatory risk, and you at least had some idea what your product is. And I think that as people begin to understand those specific details, they need to be thinking through all these different areas of protection. And part of that comes down to, early filing of your patent applications and being, I think one of the big messages that I tried to leave when I was back at DreamIt, back in August, was you need to think very carefully about your communication strategies. I think we started early, with the mention of branding and your presence and what you do. And all of these are how you're going to interface with the marketplace. And I think that's a great handle for these entrepreneurs to keep in mind is, you're going to have a way that your idea is going to be manifested within the patent system. And how are you going to do that? How will you distinguish that? And it's not just that, you're going to have the only idea out there. I mean, you'll have some form of IP protection. I think, Kyle can probably, tell you, just like any other, patent practitioner, if the claim is narrow enough, it will be allowed. It may not have any commercial relevance. And I think that's really, if we could, bound this, and I want to turn this over to Kyle to talk about, how do you get commercially relevant coverage? And everything that we're talking about here is commercial relevance. How is it that, what's relevant about going to the FDA? What's relevant about your brand? What's relevant about your patent protection? It needs to align with your company and with your commercial objectives. So a lot of this is about making the dog food that your dog wants to eat. So wherever it is you think you're going, and I think this is, so it's commercial relevance, and then the next one is, what's your end game? And if you're going to be acquired by a large company, well, then you need to be set up and doing the things that are reasonable for what your company is, what you're doing, and where you're headed. And so that's that test of reasonableness. Do you need to be prepared for worldwide litigation to protect your rights in every jurisdiction possible? No, that's outrageous. Nobody does that. Even big pharma doesn't do that, and they file probably in the largest number of countries on the planet, but they don't even behave that way. So I think I want to get Kyle in here to talk about, we talked a little bit about, for health tech, what the FDA piece looks like. Software has been getting bloodied and battered. It's just laying on the doorstep of the patent office. So maybe if you can unpack that a little bit, whenever your clients come to you with, hey, Kyle, here's my new digital widget, how do you advise them? And then I know in your background, you've done a lot of work with, some of the larger, medical device companies that are out there. What kind of food do they like to eat? Do you see a difference in the way you work with your startups versus how you work with the big boys? So Kyle, can you unpack that for us?
Yeah, sure. Lots of questions there, but let's start with the beginning of what do you need to cover? And I think the first place to go is, do we have a patent or a claim that is directed to the actual product that you're selling? The problem comes in that you draft a claim that ultimately results in coverage to some embodiment that's no longer used or that's not sold. And you end up spending time and resources trying to get coverage to something that ultimately isn't even covering your product that you're doing. So when you're filing these applications, make sure that they are covering not just the iteration you're working on at the moment, but places that you are working and that you're generating additional descriptions of. Something that I see all the time when we're involved in litigation is that the company now has a product that is the third version, and their original version of the product may be covered by the patent, but now what is being copied, maybe by a generic, is no longer covered by that patent. That's a problem. If you are the generic, or if you're the small startup company, you want to have broad disclosure in your patent application. You may want to narrow a claim at a certain point so that you can get some coverage if that's the product you're currently selling. But ultimately, you need to move forward with something that's going to give you the ability to have a little bit of flexibility, to juggle a little bit, to move with what's going to happen with your product as it goes from making 100 units to 1,000 units to 1,000,000 units to X number of units wherever the market's going to support. So, as Ben was saying, where do we then protect these things? In my big pharma clients, we can file in 50 jurisdictions, and it seems crazy. You're going, why would you file in some of these places? And I think it's real. You need to consider, is there enough value in going into some of these smaller countries? And it's purely a value proposition. At some point, you need to think of it is just about dollars, right? So the money you're going to spend to go in a country, is that going to protect you sufficiently or give you enough value that you should even spend those dollars? Sometimes when you're asking about going into, I'm going to give an example of going into Chile and South America, are you going to sell enough units that someone is going to actually come in there and knock you off, that it's going to be then worth it for you to file a lawsuit against them? That's something you really need to look at before you spend the $10,000+ at this early stage going into that country. There are certainly countries where everybody goes into. The United States, obviously, most people enter the European Patent Union, but then you need to look at your individual particular product and say, is there value going into the other countries? That's Canada, Japan, Australia. Those are very typical ones that we see people enter. So it's a case-by-case basis, and it really depends on what product you have, what product you're selling. And certainly that changes based upon if you have a pharmaceutical versus if you have a software or a component that is going into a medical device. So let's hit right at this sort of software or business method kind of issue that's going on in the courts. There was an interesting panel yesterday for one of the Northern District of California judges who's just retiring, and he says the judiciary hates Alice. They hate what Alice has made because, and Alice is the famous Supreme Court case that has basically said you need to generate a business method or software or something that meets this 101, this section 35 USC 101 limitation. And there are burdens there. So what are our clients doing? Ben, I think you would ask. And two things. One, are you generating some product or IP that has a sufficient lifetime that it is necessary to get patent protection on? So if you are in a software industry where you know that the product that you're generating is going to be gone in 3 years, there may not be the appropriate burden, there may not be the appropriate reason to go get IP protection. One, you're going to disclose to the public much earlier than you would otherwise have to about how to make, use, and sell, et cetera, your invention. So if you're using a product that's going to have a very finite lifetime, you should have a strategy in place about why or why not you should be getting patent protection. And that would go right to Christy, I would argue, is how then are we going to protect this asset if we have something that may have a particular finite lifetime, but in this short 2 or 3 or maybe 5 year period, I have a huge market opportunity. So Christy, I'm going to let you talk about that real quickly because it's a natural segue.
Yeah, it's so good to hear, all the granular details. It's validating to hear all the granular details and struggles that, startups or big companies may have with the FDA, because fortunately for me in my line of what I do, the U.S. government, if you can believe it, has built into the Trademark Act the benefit of getting protection that bides you and gets you through the time period while you may be struggling with getting FDA approval. And that is to say there's an intent to use type of trademark application you can file to protect your brand, which means you can file that at least 3 years and usually more before you ever actually have to use the mark and substantiate your application for registration through you. So that is to say, first things first, let's do some clearance and availability searching, pick our brand, get married to our brand, but before we can really start to build some equity in it, we've got to go through the FDA and any other regulatory processes. And while we're doing that, we can put an application on file with the USPTO. And it's called an intent to use application, which means the applicant says, hey, I've got a bona fide intent to use this mark, but for whatever reason, whether it's FDA approval or whatever other hoops they're going through, whether they're looking for funding, whatever it is, you get the benefit of time to substantiate and actually bring to market and use the brand in commerce. So I hear from startups all the time saying, well, we don't have FDA approval yet. We don't have any capital. We can't launch. That's okay. If you have a brand and you have an idea for the brand, we can get an application on file, get some preliminary protection. And by filing that application, you actually get a first use date. It's called a constructive first use date that would actually trump later companies that come to market with a brand that is the same or confusingly similar.
And Chrissy, is that sufficient protection for a startup? I mean, these startups don't have very much money. Their expenses are limited.
Yeah.
They're focused on developing their companies. Is that sufficient protection?
It is. I mean, use, obviously an application that's substantiated through use is stronger, but getting an application on file gets you that constructive first use date. That's your intent to use filing date. And that might be it could be 10 years before registration ever issues, but typically you get at least 3 years from the time the mark is allowed. So, yeah, and the other thing too is what's good for startup companies to know is it's not really a cost prohibitive process. I understand sometimes patenting can be, and that's not to knock what Kyle does, but patenting for a lot of startups is a scary proposition. Trademark, on the other hand, you're spending $275 for the government fee, and then obviously more for lawyers' fees, but it's really not cost prohibitive. On the flip side of that, if a startup is able to make use of their brand in commerce sooner, without waiting for any kind of regulatory approval, they do have what's called common law rights in the brand. And those rights are enforceable in federal court or against third parties, assuming there's inherent protectability.
I guess along those lines, because actually this falls into a line of questioning that came from Nishi, one of our viewers.
Yes.
If in fact there is a perceived infringement or violation, what rights does a small startup have, given that they don't have resources? If you're not going to go up one of the Fortune 100 companies, what do you do?
Well, this is, trademarks is a great area of the law because the mom and pop pizza shop in Arizona can beat the Fortune 500 company in some areas if they've got prior use. Common law rights, so say we've got a startup and they're actually using their brand, they're relying on common law rights. Those rights are going to be related, they're going to be limited geographically. If they're using them on a national basis, or if they've got an application and protection through a federal registration, first in time is first in right in the U.S. So it sounds like, and I did read Nishi's question, it sounds like, we're talking about a startup that has gotten married to its brand and started some activity under that brand, and then along comes the, Goliath beating them up. If Goliath has first use and also has, some extended protection, Goliath is probably going to win. But if the startup company has taken the steps to clear and protect its brand through a registration or actual use, again, first in time is first in right. They may just beat back Goliath by virtue of the fact that they've been using the mark. Yeah.
Jim, have you run into that situation?
Actually, yes. And trademarking was the best option for the folks that I was working with at the time. And it seemed to carry over because it kept all the big people, all the big guys, at bay, at least for the time being. Mm-hmm. And they were pretty successful with it. The intent was, once they had commercialized the product enough so that they could get some working capital together, they were going to then go ahead and file for the patent. I'm not working with them any longer, so I'm not sure if they actually did that, but that was the intent. But that's the only example I've got.
We find, though, that filing a provisional patent application and an intent to use trademark application are often things that we kind of do at a similar time. And we've talked a little about the sort of when you do these things and the steps you need to take. No question a patent you need to file or have something on file before you've made those disclosures. With the trademark, as Christy mentioned, you can file an intent to use application. But I caution you, and I know Christy would say the same, please do a clearance. Take a look at what is out there, because what happens is you spend time, energy, and resources developing a brand, and then you get a nasty letter from a big company, and the vast majority of the time, it is not worth it for you to fight it if you have not already spent all of these resources. If you have, that's a problem. You may lose, and Christy and I would be the first to tell you, move on. Don't fight this lawsuit, because you're going to end up either paying someone's attorney's fees or worse. And so getting a clearance is something that Christy and I do on a daily basis. and we talk through about those risks and what to do. It's just so critical before you start using your brand. So go ahead, Christy.
Yeah, this is where, being the sole female panelist, I guess I get to give relationship advice to you guys. What I said, date before you get married, and if you like it, put a ring on it. So the date before you get married is do a clearance and availability search before you get really married and before you invest in the brand. Because, you know, there's two prongs. You got to look at inherent protectability. Is your mark descriptive? Is it your surname? Is it too weak to be protectable? Number one. Two, hey, does a third party already have it? Are you literally infringing on somebody else's brand that they've already got? So that's the dating before you actually get married, because I have had startups walk in and they're so in love with their brand, and come to find out there's a third party out there that's been using or has protected their brand prior to. So, you know, as Kyle said, you got to tell them to move on. It's not so easy to tell them that. And then if you like it, put a ring on it. You know, once you have settled on a brand, filing that ITU application and starting to use as early and often as possible is always a good move. You know, the ITU application, again, buys you a lot of time to get your ducks in a row, but it does get your foot in the door, and will be able to help you establish a first use date that could be prior to you know, a later competitor.
I also would add, I think this is a place where spending some legal dollars is a very good idea. I know Christy and I both work in this area with a lot of startup companies, and people say, oh, I already have my brand picked out, and I may have even already filed my trademark, and there's been no clearance, and you know, there's been a lot of time and effort spent on something that I ultimately need to say, please find a new one. Without totally jumping over, I'm looking at a Q&A from Efrain Ribeiro on this Alice decision. I'm happy to speak up unless anybody wants to pop on. But the number one thing I would add, again, this still goes with the trademarks, is what are we doing with these applications that we're filing? One, take a look at your brand and how you're going to use it. Two, is it something that you should be filing an application for? Do you have enough duration on this product that you're using? And three, when we draft an application that I would say falls under, quote, Alice, I tie it to a physical object. That's the number one way of doing it. Do you have something that you can say it's two computers communicating with each other? Do you have a device? Do you have a component? Do you have something that is a physical object that is not just an abstract idea? As a quick answer to a frame your question, hopefully that answers it. So I'm going to pass back to Phil.
Yeah, Ben, I think you probably had a little bit of comment to make.
Yeah, I just wanted to spring off of the discussion about clearance that we were looking at for trademark, and the same is true in the patent field. And one of the things that I would encourage is to, you know, it's not exactly that you have to invent everything yourself. You know, what we're talking about is your rights. These are rights to enter commerce. And, you know, that's what other people have established rights. They have a right to protect what they're doing in commerce. That's really the underlying element in both, you know, trademark and patent. And that right is limited. You know, we already heard, you know, common right, that's limited by geography. You know, there's really interesting, you know, trademark cases about, you know, rental cars, and it's someone's name, and then there's a national brand. And, you know, so of course they're going to always be able to trade, you know, where they are. You just think about Paul Revere wear. You know it's the genuine article, those kinds of things. The real McCoy is actually a great patent case about braking on trains, and you wanted the real McCoy, so it became both it was a patented article, and it was also the name of the company. You know, there was the McCoy braking system. So there are a lot of times, and they get mixed in, and it's really about, you know, once you create that value, how do you protect it in commerce? And that's also similarly in patents, it's limited by the field. So you can have a, you know, quote, a broad patent, but they can be divided into a number of different fields that are independent of, you know, whatever, you know, one field can be used exclusively or non-exclusive with another. So I think a lot of times whenever people do like freedom to operate, you know, you get that or FTO that gets thrown around a lot. It's really about understanding what's out there. And the same thing is true on the patent side. If you see that, you know, if you're going to do a medical device play and you see that Boston Scientific has been, you know, plowing that field, for the last 5 years, it's been one of their leading R&D efforts, and they've spent millions of dollars and have the patent applications filed right around it. You need to either be a lot smarter than all the people at Boston Scientific, or you need to decide that you're going to move on and do something different. And this, it goes back to the comment I made earlier about reasonableness. It's really we're at no-brainer stage now to go onto Google, go onto any of the number of databases that are available for very inexpensive, we're talking hundreds of dollars here. And I think it's the intellectual sweat equity that every innovator should invest in their own idea. Just like you would, looking on Google and putting in the words or whatever it is that's descriptive of your mark will tell you whether or not someone's using it. And if it's in a field related to yours, probably not a good idea. The same is true in the patent realm. So if you come across someone, and I always use this, and apologies to anyone from Topeka, but if you're banging away and you find somebody, some physician that just got a wild hair out in Topeka, and he filed a sort of a little vanity patent, but it's got your idea in it, find out whether it's available and go buy it. I mean, you don't have to file every patent application yourself, and you never know what this other person is going through. They may want to sell it. They may have just, whatever, or they may think, oh, that's great. I'll tell you what, I'll give you a license non-exclusively. Great. All you want to do is take away the risk that somebody else has a superior right to the product that you want to enter into commerce with. So get a license and use that. And I think that's some of the companies I've worked with that I've been so impressed by was their willingness to somebody else. Yeah, there's a university that's had grant money for 3 years in this space, and they've built up quite a little war chest. Great. Go get a field of use to that entire war chest and put it into your company. That doesn't cost as much money as building it yourself. Plus, you're going to have to try to get around them anyway. And you begin to add together rights that you've got uniquely to you, and then the other rights that you acquire from licenses or acquisition, and just put together the IP that you need in order to enter the space and not worry about that. Nothing quenches the enthusiasm of an investor than to have you be unaware of developments by major companies in a space which is likely to be your exit, because most things are by acquisition now. IPOs are increasingly rare. So you're going to be acquired, and then in someone like, for example, I'll keep using some of the larger medical device companies. Medtronic doesn't buy you so that they can get sued and get into a lawsuit with Boston Scientific. If you've got a clear problem with one of the big guys, that's either going to be a great selling point, in which I've done that many times. That's the reason why you want to buy us, or it's going to be the reason you never get anybody to write a check to back your company. But you have to be aware of the risk. And it's just a matter of how you explain that risk and why your company, even in the face of that risk, because remember, we're talking about venture capital. This is not if this was a no-brainer, then everybody would be doing it. So that I'm not saying you can't have those kinds of risks, but you have to be aware of them. You have to articulate a strategy that says that this is, even in spite of us being there, that's what makes our value proposition so great.
I would really encourage all the viewers to review this information that we're presenting right now. I'll tell you, the culminating events of the Dream It cycle that we take our startups through is we actually do a roadshow. So at the end of the cycle, we actually put our startups in front of leading VCs from across the country. I'm going to tell you that in those meetings, the VCs expect for our startups to have considered all the things that are being discussed right now. And not that you have to have a definitive answer, but they want to know that you address these issues, that you're aware of them, and that you're not going to just expose their dollars, their risk to this big question. It's absolutely essential. I would encourage everybody to review the discussion, go back over these answers, and take whatever notes you need to take, because these questions will come up again.
That's right. I mean, that's exactly what it is. And folks, really, it is not that they're expecting you to have the answer or to be the expert, but they are absolutely expecting you to have seen the issue, to be aware of the issue, and there's a huge difference between being a maverick entrepreneur and being an idiot that's walking into certain danger. I call them propeller blades. If you just want to go walk into a propeller blade, do it on your own dime. And so so that's like knowing that the risk is there and then being, blatantly unaware of it or refusing to adapt your strategy. That's, sometimes that's great, and sometimes that's walking into a brick wall. And I think that, and investors will work with you on that. And a lot of times that's what you want, is to someone that knows that play, because this has all been done before. But, you know, it just depends on what your source of capital is. You can go out and tilt against Boston Scientific all day long, but just don't plan on doing it with somebody else's money. Because if you're going to take their money, it's exactly what Phil said. I want to know it's going to come back to me. And if you're ignoring clear risk in either your regulatory, your compliance, your intellectual property, if you haven't thought through how you're going to be getting, you know, how is this going to get into policy so that it actually gets reimbursed? CMS, great. There's a CMS code, terrific. No insurance company puts us into policy. Fantastic. It'll never get paid for. So unless you're going to be out of pocket, and that's what I mean by the recording, just to bring it all the way back to the beginning. You have to think about this from bumper to bumper. They want the whole car. Don't tell me about your trunk and don't tell me about your rims. I want to know from beginning to end, what's your story and how are you going to face all these risks? You don't have to have the perfect answer, but you don't want to be flat-footed going, yeah, you know, I think we're going to get around to whether or not we've got a right code for CMS someday. Good luck. They're going to say, great, come back when you know what the answer to that is. So just, you know, short circuit that.
Yeah, we don't want those answers, and we don't want the deer in the headlights response either. Jim, what do you think?
Well, actually, to Glenn's fabulous points, and I agree with every one of them. When it comes to the bottom line, which is getting money for your company so that you can move an idea forward, I know a lot of VCs and I know a lot of angels, and they all ask 3 questions. Who's gonna pay? Who's gonna pay? Who's gonna pay? And that's it. So you better do your due diligence, just like we've been talking about here. Otherwise, nobody's gonna care.
I tell you what, I think that is actually, and Jim and I were very much a part of that here in Northern California. You know, the lab that Jim set up, I can't tell you how many clients were, you know, I got to do a large animal on this Thursday, Jim, and it's late on a Wednesday, and you would be doing a large animal that next day. So he has really helped so many startups out here, and the whole Stanford biodesign ecosystem that we've been with for you know, a decade and a half. And I got there's a part of me that says this is going to be my penance for every you know, entrepreneurial physician and engineer that we took you know, $1 million A round because it was a great idea, and we shoved that technology into the healthcare system and forced it down its throat. The people that were at the end of that conga line that we never saw because the people got acquired, they didn't feel that pain. But a lot of them are now, and it's exactly what Jim says. If you haven't thought about policy, and you haven't thought about payment, and you haven't thought how that payer is going to deal with you, you are in for a world of hurt unless you've got something that, you know, only for plastic surgeons in Beverly Hills and it's all out of pocket. But setting that off to the side, you know, that it is, and I really do believe this is payback. The healthcare system is completely bloated with technology, and there are scary things that hospital CEOs are saying now about technology, and that should make all of us take pause. You need to really think about the pain point of the person that you are going to help, and it really comes down to the payer and the hospital system. And I think that's one of the big problems we've got now. Whole bunch of people, they go off and read something from Steve Blank, and they think, oh, I'm going to go be a healthcare entrepreneur. And we basically have a bunch of IT people running around thinking that they're helping, and they're really not. You know, so I think it's an awareness of the total health. That's why I keep going back to this bumper to bumper, beginning to end. What's your idea and who's going to pay for it? And you need everything in the middle, which is why this panel is so important to think it all the way through. Because right now, if you can come in and be one of those people that says, look, this is the pain point for this payer, and there's a $300 million cost of care episode in there. My company helps get rid of that $300 million pain point. Great, tell me more. And this is not, I'm just channeling, if you want to learn about this, and I'm a huge fan, my friend Alan Russell out at Carnegie Mellon and Vital Innovation and what they did with Highmark for 4 years, they did that exact thing. And I've been telling that story for the last year and a half. You need to really think about the payer and the provider and how are you going to take money off of that. There's $1 trillion out there, folks. That's what I keep looking at. So you do the math. If we got a $400 million cost of care, we're going to reduce that and get it down to some $5 million, cost of care by your device, your innovation, whatever it is. Think how many times you've got to do a $400 million reduction to get rid of $1 trillion. That's my challenge, to dream it. And every entrepreneur, every accelerator I talk to, That is the challenge, and that's what we need to do to reform healthcare in this country. There's $1 trillion out there, folks, that is really just churn. I mean, and that's where I really look to innovators to really dig in, find those problems, understand that payer point of care, and then target your innovation there. That's what will sell, and that will literally get you will get pulled into that network. And that's for the Dream It teams especially. It's what I love about you guys, Phil. You're going to get them out in front of these hospitals and in front of these care centers, and you need to be asking them, what is your pain point? What keeps you up at night? What's burning a hole in your wallet? That's where we need to be really taking action with our innovation cycles.
Right. And as you know, Ben, that's exactly what we do at Dream It. Not only are we asking those questions, what keep you up at night, but also on a weekly basis, we're de-risking those assumptions, your business assumptions. We're pressure testing your business model. We're making sure that you have answers to every question that's going to come up in a pitch. And if it's not the correct answer or the full answer, you have a response that makes sense and that makes that potential investor comfortable that you're on top of things. So we spend a lot of time with our startups making sure that they're as positioned as they can possibly be. They've considered as many options as they possibly have so that when they make their presentation, they're as credible and believable as possible. I've got one more question before I go around. I want to ask the panel for some wrap-up comments. We're getting to the end of our time. But before we get to that, Ben, can you speak very briefly? I get a lot of questions from startups. When do we start the freedom to operate analysis? At what point is it relevant to what we're doing?
Yeah, I think and I think Kyle and Christy have already given you the underlying presumption there, which is that you need to do that in the very beginning. As soon as your ideas are beginning to form and you're thinking about it, you need to begin to understand the landscape and what are the boundary conditions on the area that you're working in. Who else has been there? I mean, let's be really honest with, and that's the other one too. You need to have a very, very honest assessment of what you're really doing. Where are you advancing, and who else has been working in that space? And just be really forthright with yourself and honest about it. Who else is there? What do I need to deal with? And you need to do that in the very beginning. Now, the full-on, an actual, rendering a freedom to operate opinion, so a legal conclusion or a legal assessment, you have to have your product defined, because there's nothing I'm sure that Kyle and Christy can, you can't, I can't give you clearance on a concept, because it's the implementation of that concept. Remember, freedom to operate is the assessment of your product in commerce. And it's the same as true. Remember, product in commerce. So if your product has a label on it, Intel inside, and you're actually Intel, well, that's the initials of all the guys that started us, and we're back in Topeka. Well, guess what? There's a little company down the street here where I am in Northern California that probably has something to say about using Intel inside on your product. So that's it. That's exactly. But if you're wedded to that and you've already put a ring on it, you're going to have to claw that ring off, or go Coyote Ugly and gnaw your finger off. But you're going to so that's what I mean. So the very, very beginning, when it is a concept, you can eliminate things that are blatantly going to already trip over something. And that's just helping you with the landscape and those kinds of things. So that, getting that sort of orientation early on, keeping that fresh, keeping up with what's going on in your space. And then when you actually have the product and before you commit, so as soon as you get clarity, when the elephant comes out of the mist and okay, it's an elephant, not a zebra, not a giraffe, I have an elephant, then you need to go make sure that you can take an elephant into market. And that's the freedom to operate analysis that's actually FTO. Before that, you're pretty much looking at these are probabilities, these are areas where we might have concern, this is where we might have to do some design around. But that first thing, the product has to be fixed. Otherwise, we're just kind of looking at concepts and possibilities, and it's very difficult to predict which way things are going to go. So begin early and then maintain that, and then as you get product clarity, that's when you pull the trigger on a full-blown FTO analysis.
That's actually pretty thorough. Chris, do you have any pearls you want to add to that?
Yeah, I mean, a couple. I'll keep as brief as I can. I cannot stress enough the importance of, clearance searching, clearance and availability searching prior to getting committed and marrying a brand. There's nothing harder for me than to have to tell a startup that is wedded to their brand, guys, we got a 30-pound or a 9,000-pound gorilla. that could very likely come after you because it's in your space. And I know you're in love with this brand, but you got to walk away. Where I get the benefit of the trademark area and trademarks themselves are one place where you really can get a monopoly. I know Kyle can probably speak to this better than I can, but he probably had to tell clients after doing an FTO, you got nothing. You don't have something here. You got an idea. It's not going to market, or it's too close to another party's something. Branding is where you can set yourself apart. So if I have a client, whether it's a startup or a Fortune 500 company, walk in my door and say, hey, we've got this great idea. We're going to come up with this little box that pops up on your monitor, and you can put a term in it and hit search, and it searches. You got a search engine. All right, well, you don't have anything there, but you can't come out with Google, but you can call it something different, and you can create, you can build up brand equity. And Google obviously has the market locked up as far as being Google, but Bing can come along, and if it can build up the brand equity that's competitive, you've got something. So if it's a startup that comes to me with something that, hey, may not be patentable, may not be otherwise protectable, but it's something that we can brand and take to market, under a unique and distinctive brand that distinguishes that company, then they do have something. So, maybe they've gotten turned down on the patent side. Maybe there's nothing that's, really a trade secret, but they do have a brand that they can support and get behind and enforce. They've got something, and necessarily all startups do have a brand. It's just got to be something that we've cleared and they've thought about protecting.
This is, and guys, this is a great discussion. We're actually running out of time. What I'd like to do before we end, I'm the type of person I think in twos. Most people think in terms of threes. I think in terms of twos. We have tons of people that are watching. There will be tons of people coming back to review this session. If each of you could leave a viewer with 2 pearls to walk away with, it, they really need to focus on when they're looking at these regulatory challenges, what would those 2 pearls be? Real briefly, Kyle, what would your 2 be?
Yeah, I think the first is know the market that you're entering and know the competitors. So Ben talked about, okay, I have a device that I'm trying to go into a field. Who are my competitors? What are they doing? And do I need to know about the various components and aspects that I need to sort of design around? Maybe that's the case. And 2, I'm going to echo again on what Ben said is the moment that I know I have something that is different than my competitors, what am I going to do to solidify my rights in there? One, should I be filing a patent? Should I be filing a trademark? Should I be filing design patents? How do I protect this entire asset so that I can then go to Ben and Jim and the VCs and say, this is what I've done. This is the product I've created. This is the market we're going to. These are my competitors. This is how I'm going to win, and this is who is going to pay for it. Answer those questions by starting early and making sure that you're designing a product that's going to get you to that answer.
Great. Jim, what do you think? What are your 2?
I'm going to go with Kyle about starting early on everything, especially the regulatory path, and knowing and understanding what that path is. So there are actually 2 points here. Don't be afraid of FDA or the regulatory agencies, and 2, engage with them early and often. Great.
Steve, what do you think?
Yeah, so everybody's stealing my words here. To channel Will Ferrell, strategery. You need to do your diligence early and understand all these paths. And before you draw your line in the sand there and commit. And again, echoing the going to FDA early, they can be terrific partners, and they really do value themselves not as the goalie who's trying to block you, but as a partner in innovation. And you can pick their brains, and they see everything in your space that comes down the pike, and they can be an incredible resource.
Great. Thanks. Chrissy, you're up.
I'll go back to my relationship advice, date before you marry, meaning do that clearance and availability searching before you get married to your brand. And then the second point there is put a ring on it. File an ITU application as early as you can. To Kyle's point, as far as know what you're going to go to market with, you can be a little broader in your ITU application and then let the office come back to you and force you to narrow it down. So I like to tell clients, file as broadly as possible. We're not talking about patent claims here. So you can, pick your classification, identify your goods or services as broadly as you can, and then let the office come back and tell you you've got to narrow it and go a couple rounds with them. Buys you more time at the very least.
Right. Okay, Ben, you want to summarize here too?
I think the two takeaways that I'd like these guys to leave with is, control communications and know the no. So control communications, if you are saying too much and explain, putting things out on, a website or, blog posts or social media, and you think that's going to be, creating buzz, there's a time for that. And I think a lot of this is you really need to know when it is to speak and when it is to keep quiet, stay inside the TP, stay under the radar. So really, I think controlling communications, being very crisp about that. There's a lot of times whenever less is absolutely in the company's best interest. And then know the no. So know the N-O. Know why someone's going to say no to you and know what it is they're going to say no to. So if you're going to an investor who predominantly invests in things that have a return in 2 years, and you've got a new PMA artificial kidney, chances are there's only going to be heartache. In 2 years, you're just not going to have enough. The same thing with a payer or a provider. If you know that they don't put your product into policy, don't waste your time talking to them or rethink your strategy. So know why people are saying no to you. The same thing is true. The patent examiner is going to say no because you don't meet patentability. Same with the trademark examiner. Same with the FDA. If you're not safe and efficacious, FDA is going to say no. So know the no and control your communications.
Great. I actually had a nice little blurb written out to sign off on the session today, which has been awesome. But I think rather than do that, I'm going to read one of the comments that came in from Ephraim, one of our viewers. It says, "Thank you to all the panelists. This is extremely informative and helpful session. I look forward to the next one on this topic." That's awesome. That kind of sums it up. I want to echo that. Thank everybody on the panel. It's been a great discussion. I want to thank everybody for viewing. If anybody has any additional questions, please contact us at Dream It. If you'd like to reach any of the panelists, contact us at Dream It. We can direct you to those guys. And again, we're going to have a series of these webinars. Look forward to interacting with everybody, and thanks again so much.